We're going to continue with equal protection. So we discussed New York City Transit Authority versus Beezer on page 561, page 5, the case book, the case. So the lesson from Beezer was that even if distinction that the state makes does not make sense from a certain angle, the court will not strike that down unless it reflects a special likelihood of bias. Quote, special likelihood of bias on the part of the ruling majority, unquote. That is on page 563. If you look at footnote 39, page 562, the court more explicitly states what the standard is. What standard they will be applying in a case like this. Footnote 39 says, legislative classifications, distinctions, are valid unless they bear no rational relationship to the state's objectives. State legislation does not violate equal protection clause merely because the classification it makes are imperfect. Okay? So it's not perfect, it's not perfection that the Constitution requires. It's not legislations don't have to be perfectly reasoned. As long as it's rational, it's okay. So, barring all method and users does not make sense from the angle of finding as many good employees as possible, because if you throw out all good method and users, then you'll be losing, right, the good method and users that they could have recruited through normal screening process. And the benefit from having those extra good method and users may outweigh the administrative cost of taking them out through normal screening process. So that will not make sense from that angle, but still the court will not find it unconstitutional. How about the hypothetical of a public university not accepting applications from one region as opposed to another, just because it has received only a small number of good applications from that region? I contrasted Gangnam versus Gangbuk within Seoul. You probably think that it is unconstitutional, but you don't know why that is unconstitutional. While barring method and users is barring method and users is not unconstitutional. What could be the reason? What could be the reason that one unreasonable classification is unconstitutional, or is one reasonable classification is constitutional, but another unreasonable classification is unconstitutional? Well, we don't know exactly why, but the court has decided that certain classifications are more suspect of unconstitutionality, more suspect. 더 의심이 간다 이런 얘기죠. And they identified these two classifications as suspect classifications: race and gender. So whenever law makes distinctions based on race, the court has treated that with more suspicion. The court has said, oh, if it's based on race, it's likely to respect or likely to reflect bias of the ruling majority. The ruling majority being white in the United States. Same thing with the gender. So when gender or race are the classifications made by the state, the court has gone as far as actually making a different substantive requirement. So, I mean, so far we are talking about how rational is different from perfect, and as you will find out, the court makes distinction also between rational and reasonable. Rational means reasonable in at least one angle, right? So rational in the court's mind is not irrational. irrational, 비이성적이다라고 하면 아주 심한 얘기죠. 네. Irrational is a very, that's a very low opinion of something, right? As long as it's not irrational, the court will accept it in a situation like Beezer. In a situation where distinctions are made not based on race, not based on gender. But when race and gender are the classifications, they require something higher than not irrational. It has to be probably reasonable. Sometimes it has to be perfect. But what does it mean for something to be reasonable or perfect? The court has turned this kind of a qualitative assessment into something quantitative as follows. The court said, if the state will make racial classifications, for instance, let's say public universities will accept only white applicants because they don't want to spend too much time reviewing black applicants because they don't get many good applicants from the black population, right? If a public university does that, that will be racial classification. When that happens, the court will say, hey, you will need compelling governmental interest to justify that, and the classification or the state action distinguishing, the state action discriminating the other group has to be necessary for achieving that compelling governmental interest. So, you watch the movie Simple Justice. What is it about? Racial classification. Now, does it yes, it is a racial classification, but does it discriminate? Does it discriminate against blacks? Does it discriminate against the colored people? What does it do? It just segregates them. At least the face of the law is that it doesn't treat people differently based on color. At least the letter of the law is treat the same but through different facilities. Right? That's why segregation was such important, such a difficult question for American constitutional law. Because if it was racial classification, then it would have been reviewed under this high level of review and would have been struck down as unconstitutional easily. But school segregation didn't discriminate between two groups. They just segregated them. Are there other segregation, state-sponsored segregations? Or, all these public facilities that have toilets separate for different sexes, that's a segregation, but nobody thinks that it is discrimination. Although recently some people are calling it a discrimination against the non-gendered people, transgender and other sexual minorities who don't belong to either gender. But before we get to the cutting-edge issue, let's get to the basics. So, I'm not going to cover it in this class, but there is a case called Korematsu. In this case, what happened was the U.S. government during the Pacific War, during World War II, in fighting against Japan, administered mass confinement of Americans of Japanese ancestry. So these were American citizens whose parents or who themselves were Japanese, or whose grandparents were Japanese. Some of them didn't speak a word of Japanese, but because they were of Japanese ancestry, they were forcefully relocated from their homes to concentration camps. The idea was that they may have residual loyalty to Japan and may conduct espionage. So not all Japanese, but Japanese living in the western states. California was the biggest one. Washington State, Oregon. These are the states on the Pacific side of the United States. They were taken to concentration camps. Their classification was prominently racial. It didn't have anything to do with whether they were citizens. Didn't have anything to do with whether they speak Japanese or English. It was solely related to their racial origin. The court there applied the standard of compelling governmental interest, and if you are the government's lawyer, what would be the compelling governmental interest? What would you argue? Okay, but this was decided in 1944. Okay. What would you argue as a government lawyer? Yeah, national security. That's what they argued. But there, so national security, military expediency, And what will you argue here? Well, you'll have to argue, you have to like show evidence that Japanese Americans, expressed a loyalty to their paternal or grandpaternal country, and they did present evidence because there were some groups. I mean, there were a small number of people. Now, the court decided that this Japanese, we call that internment. It's an euphemism. It's a nice way of saying it, but they're not really interned. They were basically locked up. It was like prison camp. In 1944, the court decided that it is constitutional to do so because of a military expediency. But it did become a landmark case in terms of law because in that case, the court announced the high level of review, high standard of review for racial classification. So, this high level of review, the high standard of review applicable to racial classification is called strict scrutiny. And it set the standard so high that almost no state action, 공권력 행사죠. No state action actually has passed strict scrutiny after this. Because when they said compelling governmental interest, they talked about national security, military expediency during an active war. So, yes, the US has been at war with different countries. Actually, I think it's the country that went war with the largest number of countries. But it was the first time that the US territory was being threatened. It was the first time that a US city in Hawaii was actually bombed. So it is only those circumstances that will justify compelling governmental interest. And you cannot have just compelling governmental interest. It has to be necessary, right? So, I told you about how in Beezer, this is methadone users, this is non-methadone users. Among methadone users, there are this much good method users, all right? And yet, state excludes all method users, right? Now, if the goal is finding good employees, what do they have to do? They have to take out just bad method users, right? But they are taking it this much more. We call that what? Over-inclusion, right? Over-inclusion. Also, if you read the dissenting opinion in Beezer, the court talks about how there are other, the universe of applications or applicants is bigger, right? Not just method users, non-method users, but there are also epileptics, ex-offenders, people using, people in need of tranquilizers. So this is the good side, this bad side. Now, other than method users, there are other groups. Epileptics, ex-offenders, 전과자들, people in need of tranquilizers. Now, these people are not banned, right? If the idea is really to take out bad employees, states should not just take out method users, they should take out these other people as well. But they are not. In that sense, it's also under-inclusion. But the court, the Supreme Court, is saying, okay, maybe it is under-inclusive, maybe it's over-inclusive. It's okay, because all we want, the standard that we are applying is whether it's rational. We are not challenging the state action to be reasonable or perfect, but only not irrational. So, if classification is not based on race, based on gender, then it is subject to rational basis review, and the standard there is the state action has to be aimed at legitimate interest, and it has to be rationally related to that legitimate interest. And we call this rational basis review. But if it is a racial classification, there has to be much close fit between the goal and the action. So, under strict scrutiny, under-inclusion is not allowed. Over-inclusion is not allowed either. Okay? Any question, comments so far? Okay? Or let's go to page 610, Washington versus Davis. So, what is this lawsuit about? So, this is a test given to the people applying to become police officers. And the results of the test show that more black people, not in absolute number, but in proportion, more black people fail the test than white people. I mean, in absolute numbers, of course, more white people failed, because probably there will be more white applicants, right? But in proportion, a larger proportion of black applicants failed than the failing portion of white applicants. So black applicants sued, saying it is a racial discrimination to write the test or to give that test to people. What did the Supreme Court say? So you call this impact discrimination. So look at page 611. Second paragraph, like third line, says the proposition that a law or other official act, without regard to whether it reflects a racial discriminatory purpose, is unconstitutional solely because it has a racially disproportionate impact. That proposition is called impact discrimination claim. So it's not explicit. It doesn't explicitly discriminate blacks versus white. What it does is it creates the result of disparate impact for different racial groups. What should happen in this setting? We didn't we are in the process of perfecting the scheme of constitutional analysis here, but under the partial scheme that you have learned so far, where would you put it, this disparate impact claim? Will you put it over here because it has racial impact, or will you put it here or somewhere else? Where does discrimination exactly take place? Or to ask the question more accurately, by which line people are really discriminated. Are they discriminated by racial line in this case? No, right? They are discriminated by what? By the test scores. What does the court say about a situation like this? Are there cases where racial impact was considered unconstitutional? Look at page 611, paragraph 3. Strutter versus West Virginia established that the exclusion of Negroes from grand and petit juries. What's a grand jury? What's petit jury? If you had time, you could have looked up in the dictionary. But you should just satisfy yourself that those are juries, and you know how juries are impaneled. Right? Juries are recruited from ordinary people through a procedure usually based on randomness. So, grand and petit juries in criminal proceedings violated the Equal Protection Clause. So, what happened was, whenever black defendants, whenever the defendants were black in criminal proceedings, when the prosecutors picked the jurors, they'll exclude blacks. Now, so these are general population, and through lottery they are brought to a voir dire system. Repeat after me, voir dire. Voir dire means, voir means see, dire means ask. So voir dire means interview. So jury interviews. So prosecutors interview people for serving in the jury. Okay, that's voir dire system. And after voir dire, prosecutors can disqualify people, and whoever remains become the jurors. And prosecutors will, and through the voir dire system, what you get is all white jury. Now, there's no law that says only white people can become jurors. But the discretion, prosecutors use their discretion to exclude all blacks. So the procedure itself, this is race neutral, on the book. because the law itself doesn't make distinctions. But when the prosecutors exercise their discretion, 그러니까 재량을 행사할 때, they took out blacks. There the court struck down the jury verdicts that were given by the all-white juries, saying this is unconstitutional. Why? Because the court thought that the discretion was exercised with racial motive. There are other cases like this. School desegregation case, or right below, Wright versus Rockefeller. That's congressional apportionment case. Okay. What is congressional apportionment? Have you looked it up? 선거구 획정하는 거예요. 선거구 획정. So making the electoral districts is called congressional apportionment, because by law each representative, each member of the House of Representatives can represent only a set number of people. So each district has to have about equal number of constituents. That's why it's called apportionment, because they have to match the proportion, okay, the proportion of constituency that each representative represents. And in doing so, you have to draw the district, right? And in drawing the district, you can easily make sure that certain group, people from certain groups are not elected, right? So for instance, let's say there are two districts. In one district, 70% white, 30% black. The other district, 50% black, 50% white. Well, let's just say 60% black and 40% white. Now, if you keep the district this way, right? If you keep the district this way, then this district, in this district, it's more likely to get a white person elected, while in this district, more likely to get a black elected. But by redrawing the district, instead of breaking it down like this, you can draw the district this way. Okay. So that you get 55% white, 45% black, And again, 55% white, 45% black. If you draw the lines like this, you get, right, you get white majority in both districts, right? Same thing here. Now, this is the population, and the legislature go through negotiation, okay, congressional negotiation. And come out with a map, electoral district map. Now, nothing in the law says whites are given preference. There is no explicit racial discrimination. But, so it's racially neutral. But when Congress people, okay, when Congress people negotiate, their discretion is exercised with the racial motive. So we get electoral district map where whites dominate all districts. So there the court said, hey, that's unconstitutional. School desegregation cases are the same thing. I mean, it's a very similar process. The school districts are like electoral districts. 학군이라고 하죠, 한국에서 학군. 그래서 학군 안에 있으면은 그 학군에 있는 학교를 가야 돼요. 그러면 학군을 어떻게 그리냐에 따라서 depending on how you draw the school district, you can make a school all white or all black, right? So on that also, so I guess that's Keys versus School District number 1, right, in that paragraph. So in all the 3 cases, the court said it will be unconstitutional, okay, it will be unconstitutional only when they find racial motive. So the court says, the second paragraph from the bottom, this is not to say that necessary discriminatory racial purpose must be expressed or appear on the face of the statute. 그러니까 법 조문에 들어와 있을 필요는 없다. Or that a law's disproportionate impact is irrelevant in cases of involving constitution-based claims of racial discrimination. Disproportionate. 비례성에 어긋난 결과가 무의미한 건 아니다. 그리고 invidious discriminatory purpose may often be inferred from the totality of relevant facts. Including the fact that the law bears more heavily on one race than another. It is also not infrequently true, 그러니까 often 그런 얘기죠. It is often true that the discriminatory impact in the jury cases, for example, the total or seriously disproportionate exclusion of Negroes from jury veneers. jury veneer는 배심원 후보들을 jury veneer라고 불러요. jury veneers may, for all practical purposes, demonstrate unconstitutionality because in various circumstances the discrimination is very difficult to explain on non-racial grounds. Okay. So the court is saying that need racial motive. I mean, for race-neutral statutes, you need a racial motive. Racial motive doesn't have to be spelled out on the statute. But at least, I mean, if they can get confession from the congressman or school supervisors or the prosecutors that, we excluded blacks on purpose, then that will be great. There will be direct evidence. If there is no direct evidence, the court says, well, there can be circumstantial evidence. What is the circumstantial evidence? Well, if it cannot be explained on any other ground. Like in a case like this, let's say there was a river cutting between rivers, so I'll use blue color here. River flowing through the two districts, so that people in this district didn't really associate with people in other districts. But in congressional apportionment, they drew this line cutting through the river, so people not talking to one another become part of one district. In a case like this, people will be very suspicious what the motive behind that redistricting. The process of changing the district lines is called redistricting, because you are recreating districts. So, what does the court say about this test? This police hiring test. Page 612, the second paragraph, right in the middle, the court says, the test, which is administered generally to prospective government employees, considerately seeks to ascertain whether those who take it have acquired a particular level of verbal skill, and it is untenable that the Constitution prevents the government from seeking modestly to upgrade the communicative abilities of its employees rather than to be satisfied with some lower level of competence, particularly where the job requires special ability to communicate orally and in writing. Respondents, as Negroes, could no more successfully claim that the test denied them equal protection than could white applicants who also failed. Okay. So, let's see. What does the dissent say about this? What does dissent say about the treatment here? So let's say there is a test, police hiring test, and let's say 80% of blacks fail, while 30% of whites fail. Does this reflect a racial motive? What does dissent say? Actually, sorry, it's not really dissent. I'm sorry. It's a concurrence. 별도 의견이죠. 별도 의견. The second paragraph on page 613. Frequently, the most probative evidence of intent will be objective evidence of what actually happened, rather than the evidence describing the subject state of mind of the actor. For normally, the actor is presumed to have intended the natural consequences of his deeds. So, the concurrence is saying, okay, racial motive is important, but it's really hard to get to the racial motive. Not just that, so the court says it is unrealistic, right? It is unrealistic to require the victim of alleged discrimination to uncover the actual subjective intent of the decision maker. And also, when it comes to the Constitution, does the motive really matter? The concurrence says, a law conscripting clerics should not be invalidated because an atheist voted for it. 성직자들을 징집하는 법. 성직자들은 이제 종교적인 이유로 병역 거부를 인정받기도 하는데, 그러니까 성직자들을 징집하는 법에 무신론자가 atheist, 들이 이 국회의원 중에서 무신론자 국회의원이 있어가지고 무신론자 국회의원회가 성직자들 죽어봐라 라고 생각을 해서 투표를 했다고 해가지고 그 법이 부여가 되는 건 아니다. So it's not really subjective motive that matters. So what he says is that you really have to look at not direct evidence but circumstantial evidence. When the disproportion is so he says, underlined part, when the disproportion is dramatic, it really does not matter whether the standard is phrased in terms of purpose or effect. So he's saying, well, let's not focus too much on racial motive, because in the end, you'll never get direct evidence of racial motive. Nobody's going to pass a law that says, I hate blacks. Right? The motive percolates. 끌어오른다고 하죠. 현출된다. The motive is inferred from the evidence, from the objective evidence. Motive just doesn't sit there waiting for you to be discovered. Now, having covered how racial classification is more strictly prevented by the Supreme Court, but racially neutral law is not immediately reviewed under that high standard of review. Okay, having learned both, now you can think about Brown versus Board of Education, why that is a difficult case, and how you can solve that case. Okay, think about it, and we'll take 10-minute break. So we'll begin again between 11:55 and 12. Okay, so you watch the movie and you answer these questions. So let's go through them. Please read the passages, answer the questions below. and you read the passages, the court's position and Virginia Council's position is that segregation is not discrimination because it neutrally classifies people. It does not put one race above another. And that if colored people feel as if they are treated inferior, it is only because they choose to feel that way. Please identify the witness that appears in the trial of one of the cases, provides the best counter-argument against the court's position cited by Houston, and state that counter-argument and that reasoning for choosing that witness. Okay. All right. Who do you think was the best witness who show that segregation, neutral segregation, actually constitute inferior treatment of people? Anyone? Do you remember the movie? Yes?
I thought Mrs. Holt.
Dr. Holt. What did she say?
She argued that the African American children are bound to feel inferior due to the negative responses they face.
Okay. Okay. So they grow up having received negative responses. So once the law segregates them, they think that it is because of those negative responses, right? They feel that those negative responses are related to segregation. Okay, you wanted to say something?
Oh, the way I saw it was that like the other forms of segregation, they're like chosen by themselves, like Jewish schools or the Catholic schools, but like the segregation of Negroes from the white schools is like top-down inflicted segregation.
Okay, so who was the witness who said that?
I put Dr. Holt.
You put Dr. Holt too, okay. All right, okay, good. So relate this to the question we asked about Washington versus Davis, police test. Okay. It was not segregation, but also it was racially neutral. Right? And there we talked about how even racially neutral law can be discriminatory, right? But according to the majority, only when they find racial motive, or only when they can infer racial motive. When it comes to segregation, can you dispose of segregation under the same standard? Right? Do you need to find a racial motive? Do you need to infer a racial motive to strike down segregation? Right? Please read the following passage, explain the speaker's strategy. In NAACP office, after watching the film taken in South Carolina, what I'm saying is that we can't go to Plessy directly. We have to weaken it, chip away at it first. Weaken it, chip away at it. What's the strategy? Well, I mean, the answers are already there, right? The answers are in the question because I told you to talk about Murray versus University of Maryland, Gaines versus Missouri, Sweat versus Texas. In these cases, the lawyers didn't argue that segregation is bad. They said segregation actually constitute discrimination, right? Because to build segregated school, they have to build twice more schools. Just costs money. So it's impossible economically for the state to build equal facilities both to blacks and whites, because then it's going to cost them twice the money, right? So that's what was meant by that was also meant by this strategy. So instead of trying to prove okay, well, let me modify the statement. Here, the strategy is more about so what I just said applies actually more directly to question 3. Question 2, in question 2, there, the strategy described by the speaker is that instead of going directly to primary schools and secondary schools, they can start with the professional schools, where they can make easier argument of discrimination, because in professional schools there's really no reason to segregate races. I mean, the way segregation has been justified is that, black people came out of slavery only recently and have not received the same education, have lived in just different culture, so therefore they have to be entitled to their own independent education. But that argument doesn't work for professional schools for grown-ups. So that's why they went to law schools first. Okay. Okay, question 3. Please explain Houston's intent when he talks about going after equal first in the following passage. We have to go after equal part first, see if we can win, then we hit separate. And if we really want to win, we stay as far away from those little kids' schools as possible. How far away? Graduate school, like a law school, equal law school. Judges should be able to get the joke, don't you think? I'm missing something. How many states do you think we're likely to build a first-rate law school for Negroes just to keep us separate? They're not going to spend that kind of money, right? So here, what I said earlier applies. So instead of trying to prove that segregation is bad, they are making a second best argument, saying it's economically impossible to build equal segregated facilities. It's bound to be unequal. Do you remember Sweat versus Texas? In Missouri case, so there were 3 cases, right? In Gaines versus Missouri, the state next to, there was no law school in a neighboring state, and they had to come to Missouri State Law School. So state of Missouri had to admit that black student, otherwise he will not get equal education, right? In Sweat versus Texas, so Texas decided to build a law school, but in a basement because they didn't have money, right? They didn't want to spend money to build a whole law school for a small number of black students, so they just built in a basement with a few chairs and desk. Actually, you don't need the good buildings to study law. I mean, you're a law student. All you need is a cubicle and books and a chair and notebook computer. But still, you know, what the court said in Sweat versus Texas is that there's the intangible quality of studying together, right? And if you study alone in the basement, you don't benefit from that intangible quality, while white students benefit from that quality, right? So that's how it becomes unequal. So this is not really the kind of a straightforward attack on segregation. It's a really roundabout way, right? Trying to show how unequal it can be. Okay, please describe the difference in the boxing style between Sugar Ray Robinson and Joe Louis. If Marshall's litigation threads analogized to boxing style, which boxer does he resemble and why? The answer is yes, Sugar Ray Robinson. Yeah. He doesn't use one powerful punch. He uses a series of fast, small jabs to weaken the opponent. So he later wins on the score, although he doesn't KO the opponent. Okay. By the way, that's the father, Sugar Ray Robinson. There is a son who became as famous as him using the same boxing style. You can Google that up. Okay, please read the passage below, state the relationship between Houston's advice and excerpts from Sweat judgment. Director of the NAACP still thinks Sweat case ain't worth it. Him and Sweat, the guy they put in the basement. Therefore, maybe it's time for you to press the court to find out what equal really means. For instance, who does Sweat talk to, discuss things when he's alone, one step at a time? 2 months after we laid Charlie Houston to his rest, he died, right? The Supreme Court ruled that there was more to the equal education than building and books. Judgment of Sweat. University of Texas Law School possesses not only superior facility, but also certain intangible qualities that make for greatness in a law school. These qualities include the reputation of faculty standing in the community and prestige. Therefore, him and Sweat is admitted to the University of Texas Law School. However, we do not reach the petitioner's contention that in light of the contemporary knowledge respecting the effects of racial segregation, Plessy versus Ferguson should be re-examined. Okay. So, yes, faculties can say the same thing, right? In the basement, well, the faculties, even they are different faculties, they can say the same thing. So maybe the schools say, oh, you know, both blacks and whites are receiving the same education. But the judge is saying, no, well, hearing from a reputable faculty, reputable in the community, is different from hearing from another faculty who works in the basement. Okay? The Sweat judgment is broader than that. The Sweat judgment also talks about, as I said before, ability to discuss with the colleagues. Okay? So those intangible qualities are missing. Can you see? Do you want me to turn off the lights? Okay. Okay. That's that. And number 6. Now this is after they won the Sweat case. So they proved that segregation is economically impractical in terms of providing equal education. But now they have to get to the real argument, the central argument that segregation itself is bad. Because when it comes down to primary schools and secondary schools, there are so many black kids, and maybe it's economically possible to have equal facility for black kids in primary schools. And they don't want to let that happen. So he says, Bill, you ever read Negro Press, the Pittsburgh Courier? That's the name of the newspaper, right? You ever seen Dr. Fred Palmer's ad? Be lighter, be lovelier, be loved, right? As if a white skin is the sign of being loved. Dr. Fred Palmer's new double-strength skin whitener. Does that say damage to you? Right? This question basically gives rise to Dr. Clark's experiment. But when he goes down to Clarendon County, what happens? Number 7. If it pleases the court, before we begin these proceedings, I want to make a statement. Now we can see that the educational facilities for the colored children in Clarendon County are not equal to... okay, all right, this is another question. Strike what I said before I read the question. They're not talking about what happened when Dr. Clark conducted the experiment. They're talking about something else. Okay. If it pleases the court, before we begin these proceedings, I want to make a statement. Now, we can see that the educational facilities for the colored children in Clarendon County are not equal to those of white children. Your Honor, the legislature has just passed the Governor Byron's bill to finance the equalization of the schools. All we ask is a reasonable time to achieve these goals. Marshall, may I please the court, this is attempting to sidestep the issue. Right? So after having seen Sweat, right, after having seen these previous cases, the states have realized that they have to provide equal facilities if they want to keep segregated. So they are trying to buy them out. They are trying to buy the case out by equalizing the facilities for blacks. Marshall doesn't like it. Why? Because their objective is higher, right? They want to show segregation itself is bad. Okay. So question, you can read the passage. Okay, I'll read. I'll read for the audience who might watch the video. Dr. Holt, how do you know who you are? You get an image of yourself by how other people react to you, what they say about you. If day after day you face nothing but negative responses, you have to begin to internalize them. You feel inferior. What is most destructive about school segregation at any level is that it's legal, that the state has approved it. So the state has agreed that the people are inferior. That's what is destructive about it. Counsel for Topeka County. Is it illegality that makes it more destructive? What's your answer to that question? Is it legality that makes it more destructive? What's your question? Yes. Right? When law approves, law agrees with a proposition that people are inferior enough to be segregated, that hurts you more. It's like instead of segregating people, they can pass a law, the legislature can pass a law that says every building of a public agency has to have a sign that says blacks are inferior. There's no segregation, but just to have a sign out. Right? That will be equivalent to segregation. That's what Dr. Holt is saying. Counsel for Virginia, is it your view that the Jews also feel inferior as to status? Oh, yes, sir. Counsel for Virginia, you really believe that? Here, he was smiling. So, he was smiling because the Jews excel in academics and in many other pursuits of life. And yet, they feel as if they need to prove themselves. They still feel hated even with all the Oscars that they receive at Academy Awards and all the good schools that they go to. At some point, 70% of Harvard Law School students were Jewish. Still the majority. Many excellent contributions to the society were made by Jews. A very high percentage of politicians are Jews. Anyway, Dr. Shane answers, I not only believe it, but I have evidence to that effect. As a matter of fact, in the social science literature, the very notion of self-hatred first appeared in connection with a study of Jews. So the question is, how do they answer the difficult question of why segregating people without doing more can hurt only one side of the people? Well, it's kind of a repetition from the very first question. But segregating without doing more can hurt because right? I mean, here Jews are actually superior in many pursuits of life, and yet they feel inferior. Why is that? Well, because of centuries of discrimination and ostracization that they've faced before the modern systems have given them liberties and space to excel in these various occupations and endeavors. for 2,000, 4,000, 2,000 years, Jews were persecuted throughout the old world. They were not given jobs. They were discriminated upon. They were ridiculed. They were punished for having killed the Son of God, Jesus. And that has lived on. That memory of persecution has lived on. So there, so it doesn't matter how objectively superior you are. If you have been the subject of ridicule and discrimination, the fact that you overcome that obstacle doesn't really matter in how defensive you feel. So that is something that you should have said in answer to this question. Okay, number 9. Justice Frankfurter, I feel strongly that we should not hear these cases now. Felix, we've avoided confronting these issues far too long. I agree. I think it's time we do our job, Justice Frankfurter. Our job? I'm not convinced that this is a matter of disposition by the court. Supreme Court Justice, you are still asking for a change in social policy, Mr. Marshall. Why isn't this a matter for the Congress? Mr. Justice Jackson, we don't believe it's up to Congress to interpret amendments to the Constitution. Amendments that were clearly passed to guarantee full equality before the law for all citizens. The 14th Amendment was specifically passed to guarantee that there would be no subclass of American citizenship. Now we don't believe that Congress can vote on that. It's not something Congress can vote for or against, right? Which side are you on? Who do you think is correct? Justice Frankfurter or Marshall? I mean, you hear this debate replayed even in modern times. When you ask for a change, you say, well, let's have a discussion and we'll go by people's prevailing perceptions. We'll go by social consensus. For instance, discrimination against LGBT, homosexuals. Whenever the governments in Korea try to pass a law banning discrimination against LGBT, there are fierce oppositions, usually coming from Protestant churches. When there's when there are these fierce demonstrations by church groups, politicians come out and say, oh, we'll decide by social consensus. We don't encourage people to be homosexual. We'll do it by social consensus. 사회적 합의에 따라서 하겠다고 항상 얘기를 하죠. And of course, it looks like there is no consensus because if you just measure people's voices by the decibels, you will hear more opposition to anti-discrimination law on LGBT. instead of voices for such law. So this is a good kind of exchange in the movie showing what the Constitution should do, what Constitution does, instead of politics. Some things are political questions, but others are not. And equality, Marshall is arguing, is not. Okay, number 10. Davis. Now the Congress framed the 14th Amendment in June of 1866. The very next month, July 1866, the very same Congress voted to establish segregated schools in the District of Columbia. And from that good day to this day, the Congress never waived this policy. Mr. Davis, 1866 was a long time ago. Conditions changed. Isn't it possible that what may have seemed all right, that is constitutional in 1866, might now be considered unconstitutional? Your Honor, changed constitutions certainly may affect the laws as set by the Congress and Congress alone, but changed condition should not extend intended reach of the Constitution. As well as we all understand, it is the responsibility of the court to interpret the laws, not to make them. I respectfully submit that no reason is given here before this court to reverse the finding of 80 years. Thank you. Narrator, there was a long, terrible summer. We lined up dozens of scholars to try to make a history serve our argument. I've seldom seen Thurgood so down, so depressed, right? Because they couldn't find historical evidence that Constitution was meant to prohibit segregation. If at all, history was full of evidence that people building the United States or people writing the Constitution were accepting, permitting segregation as part of their lives. So that's why Thurgood was depressed. Professor Kelly, after the war, to get back into the Union, all the Confederate states framed the new constitutions, and not one has a single word about segregated schools. After the war, this is the Civil War between North and South on slavery. One way, perhaps Professor Kelly, the 14th Amendment has outlawed Jim Crow. Jim Crow was a system of catching runaway slaves. So it was a kind of a nationwide system of making sure that slaves are permanently held in that position. Come on, they just took segregated schools for granted. This is a goddamn wild goose chase, right? So history was full of evidence of accepting segregation. I mean, even Jim Crow, slavery was approved, which is something worse than segregation. How can you find historical evidence that the Constitution didn't approve segregation? Actually, even now, if you look at the Constitution, the text, slaves are not considered one person. Considered, I think it's a 2/3 or 3/5 of a person when they count number of people living in each state. It already shows that inequality was part of the Constitution. So what was Marshall's response to the argument here? Do you remember what argument that he made?
I thought maybe he was suggesting that the historical background of the enactment of the 15th Amendment,
Mm-hmm.
that it was like a promise of equality to African Americans.
Okay. Okay. But the Davis is saying, well, Davis would say, yes, 14th Amendment guarantees equality, but doesn't guarantee integration. Integration is the opposite of segregation. Anyone? Constitution says, so, I mean, just to remind you, the US Constitution was adopted and the country born in 1776, and about 18 something, it's only about 100 years, goes through civil war, right? They fight over slavery. And then here, the 14th Amendment was adopted. But it just says people are entitled to equal protection of law, but nothing else. How does the vague phrase there, win the argument? Let's see. 계속 눈이 아프네. When a history is full of evidence against you, how would you make a constitutional argument? Or there's a reason why it is 14th Amendment was composed of a vague phrase. They wanted to capture the ideal of equality, but they didn't know exactly how it is to be achieved. So they left it intentionally vague for people to figure, for next generation to figure out. And the fact that they were permissive of, Davis says, it is the responsibility of the court to interpret the laws, not to make them. Okay, Davis is saying, hey, the Constitution requires segregation because at the time the Constitution passed, there were already segregated schools. But is that a good argument that Constitution requires segregation? No. Right? That they permitted segregation doesn't mean that it was constitutional. Okay? The fact that they were permitting something doesn't mean it is consistent with the Constitution. Our history is full of criminal prosecutions of adultery. 간통이죠. The fact that so many people were punished for adultery doesn't mean that adulterous relationship or having sex with someone not your spouse was not part of your sexual freedom. The Constitutional Court about, when was that struck down? Was it 2009 it was struck down? In Korea. The court struck down the crime of adultery as unconstitutional. Even against the decades, several decades of have punishing it. Does it mean the Constitutional Court is making new law? No, right? So as long as the Constitution specifically orders, right, explicitly orders segregation, a vague phrase still allows the Constitutional Court to make that argument. Let me just double check something. Okay. All right, let's move to the last question. Marshall is making a powerful argument here. Okay, what is he saying? Now we all know that this is not true. Those same kids in South Carolina and Virginia, they play in the streets together. They play on the farms together, they go down the road together, and they separate to go to school. They come out of school and then they play ball together. But they must be separated in school. There is some magic to it. Now this court has said black and white are entitled to vote together, to live in the same housing development. You have said let them attend the same universities, law schools, and nursing schools. But if they attend the same elementary and high schools, the world will fall apart. That is a very powerful argument. But what did he do? What did he do to be able to make this argument? Well, he won all those cases, right? Gains, sweat, so that he could make this argument. This series of cases shows how common law works as well. how the law can change incrementally, 그러니까 점진적으로. How reasoning is not a monolith, but it is a organism that you can weaken one at a time, take away one one piece at a time, and later you can use the small success in the past to make a powerful argument. All right. Any question, comment about simple justice? Questionnaire. Now, all of you did the questionnaire, right? Even the ones who missed the first class did come, right? Now, as you noticed, it really doesn't matter whether you attended the first class or not. The questions were just something you could answer if you just watched the movie carefully. So, I'm not going to try to make up your score because you missed the first class. I'll just score the same way, and it will just become part of just participation score. Okay. Right. Having said that, we have to do some more work. So what do you think? How do you compare Washington versus Davis with Brown versus Board of Education? Why do we need to even compare the two? Well, because both are racially neutral statutes, right? In one case, the court said unconstitutional, the other, the court said constitutional. In Washington versus Davis, the court said, the test is neutral. It doesn't explicitly ban or discriminate against the colored people. So as long as there is no racially discriminatory motive to be found or inferred, no violation of the Constitution. That's what the court said. In Brown versus Board of Education, what does the court say? What does the court say here? Page 523.
educational facilities are inherently unequal, and that in the field of public education, that separate but equal should not exist.
Okay. Why? That's the conclusion. Why unequal is that? Because page 524, right? The small letter paragraph. Segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of the law. You heard this, sanction of the law, from Dr. Holt. That's what she said in court, and it went into the Supreme Court decision. For the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. Again, Dr. Holt there. Segregation with the sanction of the law therefore has a tendency, a sense of inferiority affects the motivation of child to learn. Segregation with the sanction of law therefore has a tendency to retard, 지연시킨다는 얘기죠. The educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially integrated school system. Whatever may have been the extent of psychological knowledge at the time of Plessy, this finding is amply supported by modern authority. If you look at footnote 11, there's the name of K.B. Clark. That's the Dr. Clark you met in the movie. Effect of prejudice and discrimination on personality development. So, here, what did Brown versus Board of Education focus on? Motive or impact? Impact, right? So this shows that impact alone can also become the subject of constitutional evaluation. Now, that's not the law, okay? The law is Washington versus Davis. I just want you to have that mindset of distinguishing racially neutral ones, racially neutral laws from racially discriminating laws and segregation laws, and how they compare to one another. And some people believe that it's not really the impact, it's not really psychological impact that makes segregation unequal, but that it is education where segregation is considered more damaging or more violative of the Constitution. So if you read the second paragraph of page 524, the court talks about today education is perhaps the most important function of the state and local governments. Compulsory school attendance laws and the great expenditures for education, blah, blah, blah. Talks about the importance of education, and this is dangerous to me because this means that outside education, segregation may be justified. So for instance, having, black or colored brigades in the military and have them separate from the white brigades. Is that okay because it doesn't concern education? But don't spend too much time mulling over it. all I wanted to point out was that it is not the criterion, not just the criterion of the discrimination that's important, but also the subject matter of discrimination. If the subject matter of discrimination is really important, sensitive area, maybe the level of a review has to be higher, even if it doesn't involve race. Okay? Some people believe that, some scholars believe that even if the constitutional balancing is to be correctly done, it's not just reason for discrimination, 그러니까 차등 대우의 사유뿐만 아니라 차등 대우의 영역, the subject matter of disparate treatment has to be taken into account. So if you read the 제대군인 가산점 위헌 결정에 보면 원래 평등은 자의금지 원칙 심사를 해야 되는데 바로 자의금지 원칙 심사가 바로 rational review예요. rational review. 네. 그러니까 비이성적이지만 않으면 합헌이다. 매우 낮은 심사죠. 그런데 이러이러한 경우에는 비례성 원칙에 따른 심사를 해야 한다라고 하죠. 어떤 경우에? 두 가지죠. 하나가 이 중요한 기본권이 관련되어 있는 경우하고, 그래서 이제 제대군인 가산점에서는 직업죠. 그리고 또 하나는 차별의 사유가 헌법이 특별히 금지하고 있는 경우. 그래서 성차별은 우리 헌법이 특별히 금지하고 있다. 그래서 두 가지 다 이유로 해서 비례성 심사를 해야 한다. 라고 해서 위헌 결정을 내렸죠. 그리고 그건 상당히 엄격한 심사였어요. 왜? 여성 군대 가지 못하게 한 게 아니잖아요. 여성도 군대 가서 가산점 딸 수 있어. 근데 여성들이 안 가고 있어. 그런데도 불구하고 현재 상황은 여성들이 군대 가는 것을 장려하거나 또는 여성들이 그런 직업에 종사하는 것들을 장려해오지 않은 사회 상황 속에서는 군대 갈 기회를 주기만 한 것으로는, 군대 갈 기회만 주고 그리고 군대 간 사람한테는 무지막지한 가산점을 주는 것은 여성에 대한 차별이다. 그건 상당히 그 고도의 논리가 다른 나라 헌법 결정에 비추어 봐도 that's a very, very high wire act. I mean, women are allowed to go to the army, allowed to serve in the military. It is women who do not serve in the military, and yet the court found giving extra points for military service in public employment, in public hiring, was unconstitutional, was discrimination against women, only because the social customs and the family environment did not encourage women to go serve in the army, serve in the military. There was a very strict examination, strict evaluation of the Korea's the country's culture and the law. But again, why did the court apply such a strict review? Because it concerned fundamental right and the discrimination was for reason that was specially prohibited by the Constitution, which was gender. Same thing here. I talked about how race, gender, these are kind of suspect classifications. So others are subject to rational based review, but these are subject to strict scrutiny. But even here, if it concerns very important right, then it should be subject to strict scrutiny. And we're going to learn about one of those fundamental rights, which is freedom of speech. And freedom of speech, infringement on freedom of speech is subject to, indeed, subject to strict scrutiny. And we're going to learn about that next week. And we're going to learn what it means, what strict scrutiny means in freedom of speech. Okay. So today I'm going to put on an article on constitutional balancing. It's pretty mathematical because I majored in physics in college. So even if it reads very mathematical and dry, just bear with me. It will make sense to you. It will. It is basically exposition of what I just talked about now. How constitutional balance. Constitutional law is all about balancing between public interest and private interest. Now, what determines the final result of the balancing is what standard of review is applied. Whether you require compelling governmental interest and very necessary relationship between the state action and that interest, or you just require any legitimate interest and any rationally related state action. Okay? That really determines the result of constitutional balancing. And if you keep that in mind, whenever you study constitutional law, you will be in good hands. So that's why whenever you see state action, whenever you see a law, the first thing you have to ask, what's the purpose? What's the purpose of this making this law? Anyway, to get that mindset, I'll put on the blackboard an article written by me. Thankfully, this was written in English, so everyone in this class can read it. Now, not all articles are like that. So, if you want to understand better, learn some Korean, you'll have a better idea. Okay, that's it. So, do your reading for freedom of speech, which is the reading for the third week. Okay, this is it. Thank you. See you next week.